And what did he tell you about his child support obligation?
In emails and texts, he's told me I will never see a dime from him.
Why did you say that?
Because she took my kids from me.
However, do you understand that you have an obligation to pay child support?
I understand that. I literally have no assets. All my credit cards are maxed to the max. I literally have $40 in my bank account right now.
So when you say things like, I will never pay a dime and you won't get a penny from me, do you see how to the court that would say, I'm not going to follow the court order?
In a way, yes.
Just have, like, in case we have witnesses.
Okay,
I got all of that.
perfect.
I'll say it.
Sounds good.
Yeah, you all can come up here. I think these microphones, because you talk soft and he speaks very fast.
So, yes, you all can come right here. There's a microphone right here. Is there one right here? Joey, is there a microphone over there? Okay.
No, actually, it's not. It's this one.
Oh, it's this microphone.
Put it down.
Good luck.
Can you give me? Maybe I can just,
Oh, bend it down.
I'll just bend it down.
Just a mic.
Yes.
No.
That's not a mic, or is that a speaker?
That's
That's the one for them, Judge. That's it.
I
Sorry.
can get this all the time.
I was just kidding.
Got some good? Oh,
Yeah, that one does.
Yeah.
There we go.
That's it.
So that's not
This
my
one's
microphone.
This one's yours.
I never knew
You
that.
don't need it.
I don't need it.
Fine, Judge.
Okay.
If y'all need it, we can. Y'all can.
we are close enough here that
All
I
right.
can hear everybody just fine.
Okay. Both sides. And I have real. Joy, could you type something? Okay, I see you.
Yeah.
Thank you. Yes, I can see you. And I have real time. So if anyone needs something read back, I can see it.
You said you had everything electronically.
Yes,
Did you file a proposed order?
I got it.
Then last week, just want to make sure you had that.
Yes, I had it.
Do you need a hard copy of that? You let me know.
I'll take a hard copy of that. It's not as long.
This is the one that doesn't have any exhibit sticker or anything on it.
Okay. Thank you. Both sides ready to proceed?
Ready to proceed, Your Honor?
All right. We're on the record in cause number DF 2415821. Counsels, will you please announce for the record?
Good morning, Your Honor. Andrew Kearns with Katie Lewis Family Law on behalf of the petitioner and movement, Musetta Carver, with President Clerk.
Thank you.
Attorney Benny Powell, Assistant Public Defender, Court appointed to represent Mr. Edward Scott Rulon.
All right. And those who intend to testify, would you please raise your right hands? Do you both swear or affirm that the testimony you give will be the truth and the whole truth?
I do.
Thank you. And make sure you all speak into the microphones. All right. We are here on a reset, actually, on a motion to enforce brought by your client, Attorney Kearns. Is that correct?
That's correct, yeah.
And you have tendered to the court a proposed order of enforcement.
Sure.
All right. And prior to going on the record, there were some exhibits that were pre-admitted. They will be admitted at this time. So Respondents Exhibit 3 will be admitted. And Movements Exhibits 1, 2, 3, 4, 5, 6, 7, 8, 11, 14, 15, 16, 17, 18, 20, 21, 22, and 23 are all admitted. All right. Is there anything else preliminary that the court should take up before we proceed?
Not on my side, Your Honor.
No, sir.
All right. So you all will have 15 minutes aside that will include any opening and closing statements should you all choose to make them. All of the exhibits are in, so I know it's habit to refer to those, but you don't necessarily have to. I have them in front of me. Attorney Kearns, would you like to make an opening statement?
I would, Your Honor.
All right. You're welcome. You may proceed.
Thank you, Your Honor. We are here to enforce Mr. Rubin's financial obligations since April 1st, 2025, including child support, arrears payments, and attorney's fees. M1 is a proposed copy of the order for the court. Now, the court in Los Angeles County issued a judgment of dissolution on April 7th, 2023, M2 is a certified copy of that judgment of dissolution that was registered here in Texas on October 29th, 2025. In that judgment, Mr. Rubin was ordered to pay child support of $1,515 per month, payable one half on the 1st and one half on the 15th of each month, commencing February 1st, 2023. According to the order, interest on unpaid child support accrues at 10% per year. Now, the California order was registered here in Texas on October 29th, 2024. There was a prior petition for enforcement filed on November 8th, 2024 in this court, which is court heard on April 7th, 2025. The final order for that enforcement was entered on May 14th, 2025. That was for Mr. Rubin's failure to pay support through March of 2025. M3 is a copy of the May 14th, 2025 final order on enforcement from the hearing on April 7th, 2025. In that order, the court found that Mr. Rubin had not made any payments toward his support obligation, confirmed the arrears and interest, granted a judgment for the arrears, instituted a payment plan on the arrears, and ordered Mr. Rubin to pay attorney's fees, but did not hold Mr. Rubin in contempt at that time due to a deficiency in the pleadings, specifically the amount that Mr. Rubin had paid each month. Mr. Rubin was present at that trial and represented by counsel. He has since refused to pay a single cent towards his child support obligation or the arrears or the attorney's fees. He has willfully and intentionally disregarded this court's order. This petition for enforcement that we are here for today was filed on September 15th, 2025 for his failure to pay support from April 2025 to the present, including arrears and including attorney's fees. The pleading deficiency from the last enforcement action has been addressed and it does not exist in this current pleading. Mr. Rubin was personally served with this petition for enforcement on October 3rd, 2025. Exhibit M4 is the return of service on the citation that was filed with the court on October 6th, 2025. This matter was initially set for trial on December 1st, 2025, almost 8 months ago. On that date, my client and I appeared, but Mr. Rubin and his then attorney at the time did not show up. As a result, this court issued a capias to detain Mr. Rubin and bring him before this court as a result of his failure to appear, again, significantly increasing the costs of this litigation to simply enforce Mr. Rubin's support obligation. Then on February 26th of this year, Mr. Rubin was detained in accordance with the capias, but was released before being brought in front of this court. Since he was released, we then set this matter for, we set this matter for trial once again, which brings us here today. Again, this is the third setting now. Since that original December setting, there have been 2 subsequent requests for continuances requested by Mr. Rubin that were granted. So this is the 4th trial setting we've had on this enforcement action, which again is the 2nd enforcement action we've had to pursue against Mr. Rubin for his failure to pay his support obligation. Mr. Rubin was personally served with the notice to appear for today's hearing on March 27th. Exhibit M5 is the return of service for that show cause that was filed on March 30th, 2026. To date, Mr. Rubin has still never made a single payment of child support to Ms. Carver, not one. His arrears are now $76,739.30 through June 30th of this year. In fact, he has made it abundantly clear to everyone he will never make a child support payment to Ms. Carver or pay any of his other court-ordered financial obligations. M6 is an example of that correspondence when he specifically says, "You won't get a penny from me." And he specifically says, "I will never pay a dime." Both of those are messages from Mr. Rubin to me and to my client that are already admitted into evidence, pre-admitted as Exhibit M6. Again, to date, he has not paid a cent towards his current child support obligations, his arrears, or the attorney's fees he was ordered to pay. He thinks he's above the law. He thinks there are no consequences for his actions. In fact, on March 25th of this year, Judge Lee sanctioned him $33,000 for his repeated violations of her orders.
How much?
$3,000.
For the sake of this here.
Sustain,
The sanctions are not involved in this motion for enforcement.
sustain.
Your Honor, there have to be consequences for intentionally and willfully violating court's order. This court's orders over and over and over and over again. We're asking to be held in contempt for each month that he has not paid child support since April 1st, 2025, which is currently 15 months. For each month that he has not paid his arrears since May 1st of 2025, which is currently 14 months. And an additional account for his failure to pay the attorney's fees he was ordered to pay from the last enforcement action, which are enforceable by contempt. For a total of 30 counts, that he be committed to the county jail immediately following today's hearing for 180 days, and he needs to serve the entire 180 days. Again, considering his failure to comply with prior court orders, his failure to appear for the initial enforcement action here, it's critical that he be detained immediately following today's hearing because there's a strong risk that he will not appear if the court orders him back at a later date. We are also asking the court to order Mr. Rubin to pay Ms. Carver's attorney's fees for having to bring yet another enforcement action and for causing delay after delay after delay and refusing to appear for hearings, requiring capious orders to get him to participate, and for a judgment on the arrears. The summary and affidavit for attorney's fees are exhibits M14 and M15 respectively. Thank you.
Thank you, counsel. Attorney Powell?
Yes, Judge, just briefly. So I would ask the court to consider my client's ability to pay, not just the statements regarding whether or not he did make payments, but whether or not he had the ability to pay during the months that they're actually seeking contempt. And just a statement regarding the capious. I know that Mr. Kearns is aware that there was an issue with my client's previous attorney. It's stated in his billing statement that attorney filed an emergency motion to recall the capious. So I understand that they want to paint Mr. Rubin as someone that just doesn't want to follow court orders. I mean, Mr. Rubin may get to testify just about the experience that he's had in Texas, moving from California to be close to his children, and just the experience that he's had since he's been here. But since I've been representing him, he comes to court, and this is my first time present before Judge Vonda Bailey on a contempt hearing regarding Mr. Rubin. That's all I have, Judge.
Thank you. Attorney Kearns, you may call your first witness.
Thank you, Your Honor. I call Musetta Carver to the stand.
Okay. Ma'am, just bring the microphone close as you can to your mouth.
Ms. Carver, can you please state your full name?
Musetta Nalene Carver.
And you are the mother of Franklin J. Rubin and Madeline May Rubin, is that correct?
Yes.
And they currently exclusively reside with you, is that correct?
Yes.
And under the current orders, does Mr. Rubin have any possession with or access to your children?
No.
Your Honor, I refer to Exhibit M16, which are the March 25th, 2026 temporary orders.
Okay.
Now, you currently live in Irving, is that right?
That is correct.
And you lived there since June of 2020, is that correct?
Correct.
And Mr. Rubin, he's the father of your children, is that right?
Yes.
And were you and Mr. Rubin previously married?
Yes.
And Mr. Rubin has lived in Texas full-time since January of 2023, is that correct?
Correct.
Now, we are here to enforce Mr. Rubin's child support obligation. The court in Los Angeles County issued a judgment of dissolution on April 7th, 2023. That's been pre-admitted as Exhibit M2. In that judgment, he was ordered to pay you child support $1,515 per month.
Leading, Judge.
Sustained only.
And the amount of child support that Mr. Rubin owes you is that $1,515 per month?
That is correct.
I'm object leading, Judge.
I'll allow it for background.
Well, it's not a background, Judge. I mean, that's a very important part of their case.
Which part? The decree?
What the fact that she just stated, it's not background, it's what they're actually enforcing.
Background in terms of the wording of the order?
The amount that he's supposed to pay.
Okay, so let me make sure I'm hearing this right. Are you saying your client has an issue with the amount?
I'm just saying that he has to prove up certain things in his case. Mom has to get that evidence in through a testimony. I don't think he can lead her through the testimony.
Well, I guess so M2 is already in evidence.
Right. I understand it's in evidence, but she still has to. He still has. Well, they have to prove their case. They have to prove the obligation, and she has to testify to it.
Okay. So open-ended questions, Attorney Kern.
Yes, Your Honor. Now, did you previously file a petition for enforcement due to Mr. Rubin's failure to pay child support?
Yes.
And did we have a hearing on that on April 7th, 2025?
Yes.
Was Mr. Rubin present at that hearing?
Yes.
Was he represented by counsel at that hearing?
Yes.
And did this court issue a ruling at the conclusion of that hearing?
Yes.
Now that order is currently in evidence as Exhibit M3. Has Mr. Rubin, since that hearing on April 7th, 2025, paid you any child support?
No,
Has he ever made a payment towards his arrears?
no,
Has he made any payment towards the attorney's fees he was ordered to pay?
no,
And has Mr. Rubin violated the court's orders to pay you child support every month since February 1st, 2023?
yes,
Specifically from April 1st, 2025 to the present. Has he made any payment to you towards his child support obligation, arrears, or attorney's fees?
no,
Is all the information in your petition for enforcement true and correct?
yes,
Now, have you discussed the missed payments with Mr. Rubin?
yes,
Has he always refused to pay you?
yes.
And what did he tell you about his child support obligation?
In emails and texts, he's told me I will never see a dime from him.
All right. Now, Exhibit M6 is currently in evidence. That's what's right in front of you. Now, he sent you, I want to take a look at the message that he sent to you on December 14th, 2025. What is the specific quote that he sent to you?
You won't get a penny from me for what you've done.
All right. And has Mr. Rubin told you how much he pays for rent?
Yes,
And how much did he tell you that he pays for rent?
approximately 3,000. I think it might be 2,900 to 3,000, something like that.
All right. And Exhibit M3, this is a copy of the court's order that's already in evidence. This is from the hearing on April 7th, 2025. You said the child support he owed you was $1,515 per month. He has not paid any of that since that hearing in April 2025. Is that correct?
That is correct.
And then as far as the arrears that were owed to you for the unpaid child support, the judgment at the time of that hearing in April was $47,924.50. Is that right?
Correct.
And he was ordered to pay that back at what rate?
$1,000 per month on top of.
And that was starting May 1st, 2025.
Correct.
And has he made any payment towards that $1,000 per month since May 1st, 2025?
No,
And as part of that order, he was ordered to pay you $6,328.92 in attorney's fees by August 1st, 2025. Has he made any payment towards those attorney's fees?
no,
All right. Now, are you asking for all the relief requested in the proposed final order?
yes.
I have no further questions now.
All right. Attorney Kearns, you have 4 minutes and 21 seconds left. Attorney Powell, you have 13 minutes and 37 seconds. Cross,
Yes, briefly.
go ahead.
All right, so Miss Carver, is it Carver or Craver?
Carver.
All right, Miss Carver. So the order that was put in place in California, that was a default judgment, is that correct?
Correct.
Third. And did Mr. Rubin, did he provide it? So if it was a default judgment, did he have the opportunity to?
Objection, all this, Your Honor.
Counsel, what's the relevance?
I mean, I would say, again, I mean, I'm gonna, his argument is his ability to pay. So it's background in terms of he didn't participate in the amount that was calculated. I mean, the court, again, it's background. The court can consider that. I mean,
But the order is in place.
Right, I understand, but I mean, it's not. I think it's relevant. I mean, as we're talking about his obligation and whether or not he provided his income to calculate what he was ordered to pay.
Sustained.
Yeah.
You may ask your next question.
Okay. All right, Ms. Carver, I have a question about your ME11.
A question about your what?
ME11, exhibit
Okay.
ME11. All right, so Ms. Carver, this is supposed to be, I guess, a report from California regarding how much Mr. Rubin owes in child support arrears. Is that correct?
I believe it's an accounting of what he had paid to the state.
Okay. All right, and this accounting starts in April 23 and it goes to April 26.
Correct.
Okay, and in this accounting, there's no balance. Is that correct?
There are no payments.
I'm objecting, not responsive.
Sustain.
I'm asking about the
The
balance.
question was, there's in this accounting, there's no balance. Is that correct?
Correct.
Okay. And if you look at the current charges, there's also for each month, there's no current charge for each month. Is that correct?
Objection, relevance, Your Honor.
Counsel, what's the relevance?
Judge, this is the document that they admitted into evidence. This is their exhibit, so it's relevant if it's theirs, if they believe it's relevant to their case. So if I'm assuming this is a registry only case. There's no Texas Attorney General pay record. So we're going off of mom's testimony, and they presented this exhibit so that they could say that he never paid. But there's more to it. It also says he doesn't have a balance. So and it also says that there's no current charges. So I think that's relevant.
Go ahead.
I'm not sure. Did you answer my question, Ms. Carver?
Could you repeat the question?
So for each month on this record, there's not one current charge. Is that correct?
Correct.
Okay. This case, did you seek the services of? I understand that this case was registered in Dallas County, but did you seek the services of the Texas Attorney General in any way?
Objection, relevance, Your Honor. This is a Texas order.
All right, I withdraw the question.
Okay.
Okay, this is a Texas order, correct? Do you all have a Texas pay record?
No.
Okay. And so how did you all calculate how much Mr. Rubin owes you in child support arrears?
It was based off of the California order, which was moved to Texas.
Correct. So you all calculated it on your own?
I assume so, yes.
Because I'm assuming as you all have interest in that calculation?
Did I personally calculate it? No.
Okay. I'll pass the witness, Judge.
Okay. Attorney Kurz, can you redirect?
No further questions, Your Honor.
All right. You may call your next witness.
Just myself briefly, Your Honor.
All right. You may proceed.
Thank you, Your Honor. Exhibits M14 and 15 are the summary and affidavit of attorney's fees. All the required information is included in my affidavit, which is already in evidence. The summary, we are requesting fees of $27,257.43. Again, this has been a result of, this is the fourth setting we've had on this. We had the issue of Capias. There have been, again, it's the third reset. So this is the fourth hearing. The expenses for this enforcement have been significantly increased as a result of Mr. Rubin's bad faith conduct. So we're asking that the court order the payment of those fees in full. Mr. Rubin also exhibits M6 sent correspondence directly to me. Sent one on December 9th, 2024, saying he'll never pay a dime. Again, on August 5th, 2025, saying that, again, he is not going to pay his child support obligation. Exhibit M7, I reached out to Mr. Rubin regarding the payment of his outstanding attorney's fees. Exhibit M8 is his response to me saying, so sorry to disappoint you, but the ruling was unjust and without merit. And so he was not going to pay because he didn't believe this court's order was just, which again is not the basis for setting aside this order. It is his flagrant disregard for this court's order. That is the reason that we are here. And I pass myself.
Thank you. Any questions for Attorney Kearns?
Yes.
Go ahead.
All right, Mr. Kearns. So this cause number currently, isn't it correct? Besides the motion for enforcement, there's also other parent-child relationship issues and litigation in this court. Is that correct?
There is a modification action pending currently.
Correct. All right. So, and in your billing, is it your testimony that you're billing your request for, how much are you asking for again?
$27,257.43.
All right. So you're saying that amount only involves this enforcement?
That's correct. And my billing statements are separated between modification actions, enforcement action. All the billing statements that are included within Exhibit M14 are specifically for the enforcement action only. There's no overlap with the modification action.
Okay. And what about the TRO? Well, there's a TRO involved in whatever. there's a TRO involved in a modification, is that correct?
Objection, relevance, Your Honor.
Overrule.
There were prior TROs filed in the modification action. There's not one currently being filed or pending.
All right. On, in your M11, there's redactions to your billing, is that correct?
Are you referring to M14?
M14, yes. There's redactions.
There are redactions.
Okay. So, so the court has to take your word that everything in here is just regarding the enforcement, even though there's redactions to the line items.
There are not redactions to line items. There are minimally redacted statements to protect privilege only. And again, these are very minimally redacted billing entries that comply with the required fees.
Okay, but is it possible? I mean, what is this? This is from August of 2025. There's a charge on here that says, should I take that one? There's one from September 3rd of 2025. And it says telephone conference with client regarding, and then there's redactions. And if I'm not in your firm, I don't know what the telephone conference was regarding. Is that correct? Just based on reading this line item.
That is, the one I discussed with my client is by definition privileged. So yes, that specific part is redacted.
But again, there's the enforcement litigation, there's also the modification, right? So okay. So you could talk to your client about something that's not involving the enforcement.
Is that
correct?
If that was the case, I would have put that under the modification action and not under the enforcement action.
Okay, if you go to September 9th, 2025, there's a line item that says submit online records request for certified copies of all records/reports to the Urban Police Department. The Urban Police Department doesn't have anything to do with this enforcement, do they?
Well, I'm trying to see if that's before or after the capias was issued. And I believe that was before the capias was issued. And the Urban Police Department has been, involved throughout the litigation. But I'm not sure exactly what that's for as far as the enforcement action.
All right, so there are some items here that are not involved in the enforcement action, is that correct?
I don't believe so, but
this one from Urban Police Department, that does not involve the enforcement action.
1 second, which page is that on?
It's on
M14.
Right. And each page number isn't numbered all the way through. It's on page 1.
if you
It's
look,
on page 2 in September, the documents from September of 25.
correct, if you look at the top right corner, it's from the September 26, 2025 invoice. And then it'll be on page 2 of that.
Okay, I found it. Thank you.
And there's also, go to January 30th of 2026. There's an item here regarding update and organized case pleadings for hearing on motion to dismiss temporary restraining. Revised index to hearing on motion to dismiss temporary restraining order. Prepare and print pleadings for hearing on motion to dismiss temporary restraining order. Update exhibits to hearing on motion to dismiss temporary restraining order.
Yeah, that would have been for the modification action.
Okay, not the enforcement. So there are some items here that are not regarding the enforcement.
It appears there are potentially 2 entries.
Yeah, but there's also some items that I can't read and I can't say whether or not they're enforcement. Is that correct?
It is minimally redacted, yes.
And I just want to count. You said this is the 3rd time here, so I'm assuming he had a rights hearing, and I asked for continuance to look at the documents in California. So are you saying that this is the 3rd time on this enforcement?
No,
Okay.
there was initially a rights hearing in November. There was an exhibit conference. There was a trial set here on December 1st. And there was no appearance. There was later a reset enforcement trial on April 6th.
All right,
Bless you.
a reset what?
A reset trial on April 6th, once we were able to locate him. which included a prior exhibit conference as well. So that would be the 4 appearances. That was then continued and reset again, and which I believe was into the beginning of June. At the exhibit conference, that's when a continuance was scheduled again and granted to July 6th. So that was the 5th hearing. There was the exhibit conference last week, which is 6, which means today is 7.
Overrule.
I'll pass a witness.
Okay. Council, I have a question on the invoicing statement for, let me scroll up. It is April 24th of 2026. It is for April 14th of 2026. April 10th and the 14th. Are both of those related to the temporary orders?
The 14th is for the enforcement.
Okay, what about the 10th?
The 10th, it looks like it's for the modification. That was for the violation of the sanctions order.
Okay, so the 14th, the affidavits of subpoenas, who are those for the?
Those are for Ms. Rubin's employers.
Oh, okay.
And yeah, or for employers.
Did you file those so we could see them on the computer?
The business records affidavits are on file. They were timely filed. Those records have also been admitted as exhibits M20, 21, 22, and 23.
Okay, thank you. I think that was the only one extra that I saw. Okay, Attorney Kearns, do you rest?
Yes, General.
All right. Attorney Powell?
Yes, thank you. I'll call my client.
All right, you may proceed.
State your name for record, sir.
Edward Sabu.
All right. All right, Mr. Rubin. So in evidence, you understand that we presented what's been marked M3, which is a copy of your 2025 tax return. Is that correct?
Yes.
Do you recall how much you made in 2025, or how much is on that tax return?
Around 14,000.
14K. All right. Do you, and it's been stated that your child support obligation is $1,500 a month, is that correct?
Yes.
Okay. Now, do you know roughly how much 14,000 is for a 12-month year? Each month, how much is that?
Around a little over 1,000 a month.
Okay. What if I told you it's a little bit closer to 2,000?
Counsel, you have 2 minutes left.
All right. So, well, no. You're right. So, okay, you're right. So, roughly about 1,200 a month.
A little less.
Okay. So for 2025, we're just talking about your child support obligation. Your child support obligation is $1,500 a month, and you're saying that you made $1,200 a month, and just your gross wages in 2025.
Yes.
Okay. So it's your argument that you did not have the ability to pay your child support during 2025.
I did not
Okay.
have the ability.
Okay. Did you have the ability to borrow money from anybody to make the payments?
I do not.
Did you have any property that you could sell to make the payments?
I have no property or assets at all.
Okay. And but you also understand you have more than just a monthly child support obligation, correct? You had to make your payments towards your arrears, is that correct?
Yes.
And there was also a request for you to pay towards attorney's fees in 2025, is that correct?
Yes.
Okay. So based on your income that you made in 2025, you're saying that you couldn't meet those monthly obligations?
No, I cannot.
I'll pass the witness, Judge.
All right, Attorney Kearns, you have 2 minutes and 54 seconds.
Thank you, Your Honor. Mr. Rubin, you currently live at 4917 Longwood Court, is that right?
Yes.
And how long have you lived there?
3 years.
3 years. Your rent there?
It was 6 months.
3 years and 6 months. And back at when you were under oath before this court on April 6th, 2026, you testified that your rent is $2,895 per month. Is that right?
Yes.
And is that still your rent?
Yes.
Okay. And at that hearing, you testified that you had, that you were current on your rent at that time through February. Isn't that right?
I was not.
You testified at that hearing under oath that you were current on your rent through February of this year.
I don't recall testing.
All right. And so you're in all of 2025 and 2026, your testimony is that you paid $2,895 per month in rent, but you only made just over $1,000 per month. Is that correct?
That's correct.
You own a 2006 Lexus GS 300, correct? Objection non-responsive.
Sustain.
You own a 2006 Lexus GS 300.
Yes, I own 2006 GS 300 Lexus.
Okay. And have you sold that vehicle yet?
No.
Do you have any evidence today of any attempts you've made to sell that vehicle?
Why would I sell it?
Objection non-responsive.
Sustain. The question was, do you have you made any attempts as of today to sell that vehicle?
No.
Right. And you said that you've attempted to borrow money. Do you have any evidence today to support your attempts to borrow money from anybody?
I don't understand the question.
Do you have any evidence here today to support your statement that you've attempted to borrow money to pay off your child support obligation?
No.
All right. Back in April 4th, 2025, you produced a financial information statement to this court. I'm going to hand you what's been pre-marked as Exhibit M9.
Judge, that document was not admitted into evidence. We went through this with Judge Lee. It wasn't admitted. We had an exhibit conference, so I'm gonna object us to hearsay.
It may not have been pre-admitted, Your Honor, but that does not mean I cannot cross-examine him on an exhibit.
This is the actually more about a document that's not in evidence.
Sustain. It's not in evidence.
Well, that would be the reason for me trying to prove up the exhibit, Your Honor, so that it could be admitted.
I mean, you can ask him questions from it.
Mr. Rubin, what's your electricity bill?
I don't know.
You don't know, but your electricity is still on, isn't it?
I don't know my bill is still there.
Your electricity is still on there, right?
My electricity died.
Yeah. Do you know what your water bill is each month?
No, it's different. It's about 86 times.
But your water's still on, right?
Okay, yeah.
Okay. You have a cell phone? Yes.
Yes.
What how much do you pay for your cell phone each month?
100.
100? All right. How about for groceries? How much do you estimate you pay for groceries each month?
I don't know. It varies.
What's your best guess?
I don't know. It varies.
All right, but you still eat each month, right?
Mm-hmm.
Is that a yes?
Yes.
Okay, you have cable and internet?
Internet.
Internet, all right. And your internet's still on, correct?
It is.
How much do you pay per month for your internet?
That was your last question, Attorney Kearns.
Understood.
Attorney Powell, you have 27 seconds left. Did you have anything else you want to ask your client?
No, Judge.
Okay.
Do I have to use that time for my closing also?
You can.
Okay. Well, I gotta say that time. Good.
Okay. So you're done with your client. You want to go ahead and close?
Yes.
Okay.
Does Mr. Kearns get to close first or?
He ran out of time.
Okay. Judge, I'll just say that based on what I heard, I heard them prove up. I heard them prove up one date for child support, which was April of 2025. You can't just say that has he since April of 2025 has he paid you anything? That's the question that I heard. And so the family code says that you have to, you plead specific dates, and they only pled from they pled from April to September of 2025. So that's the date range that we're looking at.
Okay. Attorney Powell, you ran out of time. I have a question. Mr. Rubin, on exhibit, let me check my notes. I think it was 6. On exhibit 6, you have it in front of you? Okay. Could you hand it to Mr. Rubin? Mr. Rubin, on December 9th of 2024, as well as December 14th of 2025, you said on December 9th, 2024, you said, I received a letter from your office. You're sending this to Attorney Kearns. I received a letter from your office to move child support to the state of Texas from Los Angeles. I will never pay a dime. Why did you say that?
Because she took my kids from me and falsified to the court that I abused my children in order to get a TRO on me for my children, which was never proved, not one bit of evidence so basically they stole my children from. I had 50-50 custody from the time I moved here after my daughter died. And I moved here to be with my children 3 blocks away to be the best co-parent I can possibly be. On an agreement from her to have 50-50 custody.
I'm gonna object.
And she started unraveling. She started unraveling.
Hold on, I asked.
She started
Go ahead.
unraveling my custody with my children, and that's all I have in my life is my children. I don't have any friends here. The friends I do have are very scarce. I live alone. I'm a single father. I never brought another woman to my house because I wanted only my kids to know their mother. So I hadn't gotten into a relationship because I don't want to confuse my kids with another woman in my house. So I've just been a single dad trying to do my best. And she lied to the court and said that I abused my children to get a TRO on me. Then the TRO ends and they extend the TRO for 14 days. And then they extend it without cause indefinitely. Haven't seen my kids in over 9 months. They haven't lived with me. And now I'm going to pay her to.
When you say the court, the TRO,
Yeah.
not to cut you off, I just want to make sure I'm following you.
Yeah.
Are you referring to the California court or the Texas court?
That's-
Okay.
And so I've been held from my kids without cause. And then when I went to go point out the violation of my fatherly rights and the alienation of my children, I was punished for pointing out my rights. And then finally I get to court to do this enforcement in December 1st. Again, my attorney fails me, doesn't show, gives me a text at 7:30 in the morning, 2 hours before, doesn't tell me I have to go to the court. Because why would I go to court if I have an attorney? And then she bailed on me, and then I get a warrant for my arrest and a contempt. And then all of a sudden, I'm like, where am I in a twilight zone? And then finally, I go to court to finally get my kids back in February from a TRO that was extended past the 14-day limit indefinitely. Haven't seen my kids, and then I'm dragged to jail. I'm dragged to jail because I came to get my kids. Then I have to get out of jail and figure out my life. And then I'm fired from my job.
Okay, so the next text, December 14th, 2025, you won't get a penny from me for what you've done. That's what you sent to mom. Would your answer be the same?
Literally taking my kids from me, her living in a 2-income household, me living by myself, trying to gain some kind of employment that could sustain me. And it's been a very hard time gaining any kind of employment that can sustain me, on top of it, when I was taken to jail, and they went and subpoenaed my records from the job that I thought that I could possibly make money from. They fired me because they didn't want the drama.
Okay, so that job, you're no longer employed.
No, that was because of the subpoena.
I'm an objection to
Okay.
anything after I was fired, Your Honor.
Okay, sustain. You do understand, Mr. Rubin, that I hear what you're saying, right? I think anybody understands what you're saying in terms of how you feel about what has transpired. However, do you understand that you have an obligation to pay child support?
I understand that. I literally have no assets. All my credit cards are maxed to the max. I literally have $40 in my bank account right now. I haven't paid rent for this month.
And do you understand that sending messages like that, I will never pay a dime, you won't get a penny from me?
Okay, I understand that. But over the years, I have paid her.
Objection.
Okay.
And I have paid many
Sustain.
times. And
Objection.
she's asked me for money and I've given her money.
Okay, hold on 1 second. The court, I'm talking about since you've been in front of me.
Right.
There's not been anything paid to her. So when you say things like, I will never pay a dime and you won't get a penny from me, do you see how to the court that would say, I'm not going to follow the court order?
In a way, yes.
Okay.
Yes, in a way, yes. But in a way, I'm sitting here alone in a house trying to find my way in this town. knowing nobody still. She's in a household. with two
Objection
incomes.
relevant,
Okay,
Your Honor.
that's,
Oh, that's fine.
that's not relevant,
But
but
I'm just trying to find my way, and I'm being persecuted the whole way through, having my kids taken from me, unraveling our agreement of 50.
Objection.
wait a minute, hold on one second. Sustain.
Oh, I'm sorry,
What-
that statement was made under stress and duress of my kids constantly being trying to take away from me and trying to take my custody away after I lived here, after I moved here and left all my whole life of 38 years in California,
I have a,
just to be with my kids.
I have a question for you. On the modification, is that what you all are discussing? A modification in child support, like a reduction?
No, he's never filed a modification, never filed a motion to reduce child support ever.
I did,
Okay,
but I did it. I was denied.
all right. So I have a couple of questions about the order. On page 6,
Are you referring to F3, this court's order?
oh, I'm sorry, the proposed order of
Oh.
enforcement that you gave. On page 6, it says attorney's fees and cost of $24,268.74. You testified, however, and towards the end of the order, it says $27,257.43.
Yes, Your Honor, I apologize. The 27,000 number is correct. That's updated. This was the attorney's fees as of last week for the order. When
Okay,
it was filed.
so the $6,645.37 is correct for the new attorney's fees.
The new attorney's fees.
All right. 27. So I'm just going to mark that out. And the court is going to, there are two, let me just make sure. There are two dates that I heard. I heard April 1st, 2025 and May 1st of 2025. Let me just make sure I'm correct, because to Attorney Powell's point, you do have to plead and prove up each one of the dates as they're outlined in your motion. It just can't be a blanket statement.
Correct. And so April 1st is for the child support. This court ordered May 1st for the arrears. So April 1st, 2025 is the first date that he's owed for the child support. May
Yes,
1st, 2025 is the first date that was owed for the arrears.
Yes.
That's why there's one fewer count for the arrears than there is for child support.
so the court is going to grant the motion in terms of violation 1. That's on page 3. I'm crossing out 2 through 15, striking those.
Judge, if I may, I also, and I was trying to say this, but I didn't hear them prove up how much he's supposed to pay in terms of arrears. I didn't hear the
He
original.
said 1,000. It's,
Okay.
yeah, it's in the record. He said $1,000. He said she said $1,515 for the child support and $1,000 per month on top of that. And she said, correct.
And those amounts are also pre-admitted, included in the order. And so they have already been proven up. They do not require additional testimony.
At the enforcement, they do. They do at the enforcement. So it's violation 1 and violation 16. I'm crossing out 17 through 29. Which the only thing that really impacts, because it only takes one violation to get the contempt that you're requesting. The only thing that it modifies would be the amount of let's see, it was something else I had a question about. The district clerk, the amount of $13,000 for fines.
Correct.
Where did you get that number from?
That's the 30. Well, it's at the time it was $500 per violation. So at the time this was filed, that would have been.
Oh, so you went back to the date of filing.
So it's for the 13,000. So at the time, so if all 30 counts were to be granted today, the request would be for $15,000 in fines.
Okay, so I'm crossing that out and I'm making that 1,000.
Well, I would request that for violation 26 as well. So the fine would be 1,500, not 1,000.
Which violation of that?
March 1st. I don't have March 1st in the record.
No, it's the attorney's fees. You don't pay the attorney's fees. So
Which one you said?
that's just due on August 1st, 2025.
Oh, that's past due.
Correct.
Attorney. Oh, yeah, I didn't mess with that one.
Yeah.
That's already been previously ordered.
Well, yes, that was previously ordered for attorney's fees. The failure to pay that amount is another count of contempt. And so I would ask that the sanctions be 1,500, not 1,000.
Oh, I see what you're saying. I crossed out 26 on the previous page. Okay, so let me make that edit. So just so the record is clear, violation 26 that was struck was the one related to the $1,000 child support arrearages from March 1st, 2026. The violation number 26 of August 1st, 2025, as it relates to previously ordered child support attorney's fees, that's still valid.
Yeah, and that's a count.
Yes, so that would make the fine $1,500 versus the $13,000. Do you have a commitment order?
I do know.
There, we want the minimum 3 violations.
Yes. Counsel, I don't know what to do with, I will never pay a dime. You won't get a penny. I don't know what to do with that, counsel.
I think there was a lot of context in those statements. Yeah.
And I get it. However, I don't, even your client, when I asked him, he said partially yes about not following the court order. I don't know what to do with that. I can't allow anyone, Mr. Rubin. It's nothing personal against you. I'm just following the law and doing my job. I cannot allow anyone to come in here and believe that they do not have to pay anything in child support. And these are your words. I will never pay a dime. You won't get a penny from me. I cannot let anybody, counsel, think that that is okay.
Now, I have the commitment language on page 9.
No, I actually need the commitment order. The commitment order is for the sheriff's department.
Yeah, I should go grab it.
What?
No, because I have to finish the,
Buddy, don't hurt my, what are you doing?
He's up, he's under arrest.
so the court is granting the order on the motion.
My arm like that.
He's up.
Why are you
You're pulling.
But why are you putting it tight like that on my arm?
You're pulling.
Why are you doing that?
You-
I'm not pulling. Loosen it off my arm.
You gotta be kidding me.
Okay, so the court is granting the order of enforcement of child support by contempt and attorney's fees by contempt. Specifically, the court finds that the respondent violated the order.
Please loosen it. Please loosen it. I asked.
Okay,
Please loosen these.
The court finds that he specifically ordered the provision ordering child support in the amount of $1,515 payable on April 1st of 2025. The court also finds that the respondent, Mr. Edward Scott Rubin, failed to comply with the provisions of the order as it relates to the child support arrearages
Yes, please.
May 1st, 2025 in the amount of $1,000. The court also finds that the respondent, Mr. Rubin, Edward Scott Rubin, failed to pay previously ordered attorney's fees in regards to the contempt of the child support on August 1st, 2025 in the amount of $6,328.92. The court awards the attorney's fees and judgment in the amount of $27,257.43, and that will be a judgment. The court also
Putting off my blood. Can't feel my hands. I can't feel my hands, buddy.
The court also finds that child support arrears in the amount of $76,739.30. And that is as of June 30th of 2026.
I missed that number, Jared. I'm sorry.
$76,739.30. And that's as of June 30th of 2026. That will include, as stated in the child support order from the California court, that compounds interest at 10% per year. It is ordered that Mr. Rubin pay this amount back at $1,000 per month beginning August 1st of 2026. Mr. Rubin, you're being ordered to confinement in the Dallas County Jail for a period of 180 days.
Oh, my God.
You will also be ordered to pay back the fines
in the amount of $1,500 to the Dallas County District Clerk. And the language that I am changing, it says you're committed for a period of 100 days each. I'm doing 100 days total.
Judge, can my client have a bond amount?
Yes. Did you put a line in here for bond? I don't think I saw it.
No.
Okay. Mhm. Okay. I'm crossing out that bottom language too about the counsel, how much of a bond amount are you asking for? He has $76,000 worth of arrears.
Sorry, I thought that was a question for Judge, based on the fact that we're talking about three violations. I understand the amount of arrears, but we're talking about 10% interest, and in Texas, the interest is 6%. And based on his income, I would ask for a bond no more than $2,000.
Attorney Kearns?
I would ask for a bond of $25,000.
I think 25,000 is more reasonable than 2,000.
5,000?
Yes, counsel.
Judge,
Counsel, your client said, I will never pay you a dime. I'm not paying you a penny.
but Judge,
What sense does that make to give him a bond for $2,000 and he hasn't even paid under $2,000 to her?
a bond amount has to be set at an amount that he could actually pay. Like he has to be given an amount that he could actually pay. He doesn't have any property to sell. He made $14,000 last year.
Okay, this is my question. Giving him a bond and allowing him to bond out, what does that do for mom in terms of child support?
She gets that money, and I mean he doesn't have that money on him now, so he would have to get that money from somebody.
Exactly. So he could have, in that same respect that you just said, he could have gotten that same amount from somebody while this case was pending. I put you on the case months ago, counsel. He could have paid if that's what you're saying, that he could borrow it. He could have borrowed it for that.
No, that's not what I'm saying. All right, so he's been committed, right? So we're talking about his bond amount.
Yes.
And I mean,
if I choose to entertain it, you're requesting it.
But I mean, I know there's case law that says that like his amount has to be set at an amount that he can pay. His testimony is that he made $14,000 total last year. I don't think your bond isn't supposed to be set at an amount that you can't pay. Like that's why there's.
But his child support is set at an amount that he said he can't pay, counsel.
Right, I understand that, and just because I mean I don't know what my appointment has to do with it, but I mean there's some things that I can do and I can't do.
Right.
I represent him on the enforcement, but $25,000. I mean I don't know. I just don't want to say too much, but
Okay, well, counsel, then the court is not going to entertain a bond.
no, that's not what I'm asking for. I'm asking for the court to give him a reasonable bond that he can't pay.
Giving him a bond and allowing him to bond out of jail for an amount, let's say $2,000. His child support is set less than that. The arrearages is set less than that.
It's just
But counsel, that wouldn't hear me what I'm saying. If I were to set the amount, if I were to set it at any amount, okay, this is money. If he were to come up with this and borrow it, that could have been an affirmative defense on the enforcement that he could have paid mom. Like he could have brought that in here. Look, I borrowed this $5,000, this $6,000, this $10,000 from my brother, whomever, to pay towards this. But I couldn't pay child support, right? But if you put me in jail and you set me at a bond, I'm able to come up with that money.
But no, I understand what you're saying, Judge, and it happens. But there's a difference between 2,500 and 25,000.
Okay, so this is
a big difference between those two amounts.
And I agree with you. So the court is not going to order any bond.
Judge, he has to be. The law says he has to be able to get out of jail. We can't just commit him and he doesn't have a bond.
Knows everything.
You gave him a 100-day jail sentence. Once he's released, he could come back to court. Once he's released, he can come back to court and we can revisit the enforcement.
But how long does she, while he's in jail, what does she get?
If his bond amount is at $25,000 for the next 100 days, I can guarantee she's not getting anything.
Your Honor, she's not getting anything in.
That's what I'm saying, Counselor. She's not getting anything.
So he goes to jail, right? You set an amount that he probably won't pay. All right, and he sits in there for 100 days. So then what? Then what when he gets out in 100 days?
I have nothing.
I mean, it really wouldn't be any different right now, Counsel, because it'll be different for him because to his point, he will lose everything. However, she has been funding this child, and I'm just looking at court order, sir. I'm not looking at facts. In terms of anything that's going on extra, I'm looking specifically at the court order. And what I have in front of me is no money paid in child support. And I have 2 admissions that says I'm never going to pay anything.
All right. Stand the facts, Judge.
So give me another amount, Counsel.
Okay. I'm gonna say $4,000 to $5,000.
Ask the court to deny bonds.
Judge, you can't deny the bond, Judge. All right, well, what if we do this?
Yeah, wait a minute. Until that, where does it say I cannot deny a bond when they are
It
ordered?
said bond has to be.
Your Honor, you don't have to set bond at all.
Okay.
Yeah, where does that say?
Okay.
That's what I'm confused on. Where does it say when someone violates an order and they're sentenced that I have to give them a bond?
Okay.
No, that was a question. Could you tell me where?
I'll have it on me right now, Judge, but I can, if it's there, I'll present it. Okay, but an alternative, okay? So you gave him a 100-day jail sentence, right?
Okay.
The goal is to get mom some money.
Right.
So if you give
The
him,
goal would have been for mom to get money before today, so he would not be incarcerated.
and me as his attorney representing him, I don't control what happens outside of the courtroom or outside of what I'm able to control. All I can do is argue before the judge. So you gave him a 100-day jail sentence, 100-day jail sentence, right? So if you set him a bond at whatever amount you set it at, if you go higher than 5, if he pays the bond and you say that he's ordered to come back to court within a certain amount of time, and then we address whatever days are left on the jail sentence. What? Like so that your jail sentence has some teeth on it. So that if he,
I think 180 days has teeth.
Judge, I'm trying. So what? Well, okay. I don't know. I'm trying to get past the. I think that he should have a reasonable bond. All right. Again, what I'm saying is, whatever you set his bond at, I just said an amount. I represent him. I'm going to say an amount. So if you set a bond at $5,000. And if that's paid and however many days is paid, he's ordered to come back to court and he shows whether or not he's making his payments. And if he's not making the payments, then there's still time left on the sentence that he could be recommitted if he doesn't pay in the future, is what I'm saying. And I don't know if whether or not he should be given a bond is in the family court. I'm thinking the case law.
Well, if it's case law, then it should definitely be in the code. I just don't remember seeing it being required.
Your Honor, in my experience, there's almost never been one.
In my experience of practicing law for 13 years, 5 as an assistant, 3 as an assistant attorney general.
I've done bonds in certain contexts, like for capious warrants, but I haven't done a bond where I've found where someone violated the court order, held them in contempt, and then set a bond. Now, if you can find it, I'll entertain it because I'm going to follow the law. I see a bond under a motion to reduce child support arrearages. I don't see one specifically to an order of contempt.
All right, so 157, 166, contents of enforcement order.
Hold on 1 second. This is the handbook. Hold on, let me grab my code. 157, A, right?
157, 166, contents of enforcement order.
Mm-hmm.
And then subsection B. I'm sorry, subsection C.
You said 166?
Yes. 157, 157.16.
Okay,
It says if the enforcement order imposes incarceration for civil contempt, the order must state the specific conditions on which the respondent may be released from confinement.
right, may be released.
And that's already in your order. So it's on page 8 of the order. Those are the conditions.
Did you see?
of his
Did you?
release.
Wait, say it again.
So go to page 8. Do you have a copy of this?
I don't. Okay, you said that, yeah, that he may be released, but the order must state the specific conditions. The order must state the specific conditions.
Right,
Correct.
on civil, right?
Right.
The jail sentence is criminal contempt.
And the civil contempt already has those provisions in there. Bottom of page 8, civil contempt.
Mhm.
Just like it is for every contempt order, it is, he has to comply with what he's been ordered to pay from the court. And if he does, then he can be released from jail, which means pay the arrears, pay the attorney's fees, comply with the court orders going forward.
Correct.
Those are the conditions for him to be released. And if he complies with those, great. Then we are happy to have him released from jail at that time.
Yes.
This complies with the
The civil contempt. So the part, if you go back to B, it said if the order imposes incarceration or a fine for criminal contempt, an enforcement order must contain findings identifying, setting out, or incorporating by reference the provisions of the order for each enforcement was requested and the date of each occasion, and the respondent's failure to comply with the order was found to constitute criminal contempt. Both of them are in here. It doesn't say anything for criminal contempt about me issuing a bond. Now, for civil contempt, it says I must state the specific conditions, not that I must give a bond.
Right, but.
So, and it's in here, counsel.
Right, but the bond would be a condition.
Right, under civil contempt.
Right.
This is criminal contempt. So the criminal contempt is 180 days. Counsel, I need a commitment order.
I'm gonna get you.
Yes, because that's what the sheriff's department needs, right?
And then I'm gonna go down with the first process.
Okay,
Wait, hold on, Judge, you said 180,
yes.
100, so what's,
No, it's 180. I said 180.
I'm gonna lose everything. And Judge, I'll just ask, Judge, I don't know if Mr. Kearns wants to come up. Again, I made the request for him to have a bond, right? You asked me for an amount. I said an amount. Mr. Kearns said another amount. And I don't want the court to just say no bond just because I said enough, the amount that I said. Again, I think there's a huge difference between the amount that I said initially and the amount that he said. So I don't know if it's me saying the amount that I said. I didn't say an amount just so that becomes no amount. I was saying an amount representing my client.
And counsel, I don't deny that you did a great job of defending your client. That concludes the hearing. We're off the record. Thank you.
And his sentence is 180 days.
180.